Dr. Singhvi.
Mr. Chairman, sir, I rise to participate in this extremely important debate. And you're all here at this late hour, partly because of the extreme importance of the debate.
After this, who will be?
It is not only Parliament which owes it to itself to engage in constructive debate, but not only the whole nation is watching us, but perhaps the entire world is watching us. It is watching the response of a sovereign nation, a response through its most important legislative wing. Mr. Chairman, sir, every perverse, every distorted act, every dastardly or despicable terrorist act, in a sense, still contains an opportunity, just like every calamity and every tragedy contains an opportunity. And therefore, there is in this also an opportunity. We have to only see it, we have to seize it, we have to understand it, we have to deal with it, and we have to solve it. This terrorist attack in particular has ruthlessly assaulted Indian pride, Indian identity as a vibrant, multicultural democracy. And once that pride is assaulted, we cannot afford to forgive or forget. We have to rise to this challenge. We cannot retreat to the comfort of our own cocoons of safety. And as the Foreign Minister said, we cannot have business as usual. We have to keep this fire glowing. We have to keep this anger simmering. But we have to direct the anger and the fire constructively. Friends, this debate and this discussion has to rise above politics, as mostly it has today, except for a few discordant notes. It has to rise above tutu meme. It has to be introspective and clearly self-critical. Self-critical on this side, self-critical on all sides. The sad and the honest truth is that as a nation as a whole, we are not geared to dealing with terrorism. As a nation as a whole, we have not collectively united to face a scourge unknown, perhaps prior to the 20th and 21st centuries. We have not designed ourselves to face something which is not provided for in the rules of engagement of war. When the rules of engagement of war were made in the early 30s, 20s, 40s, nobody talked about an anonymous, invisible, unknown enemy who would have no particular object, no particular target, but whose entire object was an indirect war. And therefore, while I must emphasize that we must eschew politics, because for every political allegation you make this side, I'm sure there will be more than 4 or 5 about Akshardham and about Parliament attack and about Raghunath Mandir. Every time you point an unnecessary finger this side, there will be questions asked. There is the supreme irony that many of the people we are asking now to be released or given to us or handed over to us, they include those who were handed over at Kandahar. So, but that will serve no useful purpose at all. That will only paint this nation as a nation divided and as at cross purposes with itself. We have to remember only one statistic, a very unfortunate statistic, that after Iraq, India is the country which has suffered the maximum victims of terror. Now that's a terrible statistic. We've suffered more than any other part of the globe, whether in injuries, whether in terrorist incidents, or in deaths. The only thing we are a little better off is in hostage taking, where I found that we were number 3 after Nepal and Iraq. But after Mumbai 2008, I'm not even sure whether we are number 3 anymore in the hostage count. And mind you, in this Hall of Fame, we keep distinguished company with Afghanistan, with countries like Chad, Colombia, Sudan, and so on and so forth. So that is, and that should be the only uniting statistic for this debate, for this House. Sir, before I come to the specifics, and I have a very specific wish list, because I think we owe it to ourselves to be very, very specific about what we want and how we intend to get there. Before I come to that, I wanted to make this last preliminary point, and that is that we need a surgical overhaul. There cannot be any patchwork, and the surgical overhaul must consist of a consistent policy, whatever it is. It doesn't matter whether it's a policy by this side or by that side or by any other party. But that policy should be implemented for a minimum of 3 to 5 years without mid-course zigzags. And you will see, I can assure you, results in less than 18 months. And I put that on record because I do believe that a consistent policy will make a difference. We have to remember certain basic principles when we follow that policy. One principle, I think, was typified by Margaret Thatcher in the immediate aftermath of the Falklands War. And she put it well. She said, when you stand in the middle of the road, it's very dangerous because you risk being struck down by traffic both from the left and the right. So you have to take a stand, and you have to be bold in taking a stand and not stand too long or too much in the middle of the road. Another principle which is very important for my wish list is Thomas Hardy's admonition that if you take care of the big things, of the small things, the big things will take care of themselves. So it's very, very important to take care of the small things. And let me turn, therefore, friends, straight away to the wish list. The first and the foremost, basic police reforms. Ultimately, you can have all the special NSG commandos and the black cats. The basic backbone of law and order, public order, including terrorism, howsoever special and unique terrorism may be, is the police force. And one thing we should not do after this debate is to set up yet another committee about the police commission or about the police forces. My favorite gag about a committee, in a lighter vein, I've shared this with this house earlier, is a group of the unfit appointed by the unwilling to do the unnecessary. Well, that is something which we have to avoid as far as the police is concerned. There's only one letter which we have to follow, and that's I. And I stands for implement, implement, implement. We know most of the answers. Consider this. Today in 2008, including in Delhi, ऐसे कई पुलिस स्टेशंस हैं जहां पर जो आरटी कम्युनिकेशन सेट होता है, वायरलेस सेट, उसको एक एक दो दो घंटे बंद रखा जाता है इसलिए क्योंकि एक्स्ट्रा बैकअप बैटरी नहीं होती है. यानी पुलिस हर 1.5 घंटे 2 घंटे में उस आरटी वायरलेस सेट को ऑन करती है, सूचना लेती है और फिर बंद कर देती है इसलिए क्योंकि वहां पर एक अलग बैटरी नहीं है. ये आज दिल्ली में है, ये आज देश के कई हिस्सों में है. कई पुलिस स्टेशन ऐसे हैं जिनके पास कारें नहीं है, व्हीकल्स नहीं, कई हैं ऐसे. दिल्ली में ऐसे पुलिस स्टेशन हैं जो मेकशिफ्ट परमानेंट स्ट्रक्चर्स में नहीं हैं. हमारे यहां पर औसतन 1000 व्यक्तियों के लिए एक पुलिसमैन है. अमेरिका जो काफी बड़ा देश है, संघीय प्रणाली का देश है, हमारे से कई मामलों में समान साइज का है, वहां पर जिसको कम माना जाता है 300 व्यक्तियों के लिए एक पुलिसमैन होता है. इसके अलावा बहुत सब प्रॉब्लम्स जानते हैं, हमें उनका हल करने के लिए एक बहुत ही सोच समझ के सीधा ढांचा बनाना पड़ेगा. ट्रांसफर्स होते हैं. मैं कल एक पुलिसमैन से बात कर रहा था, बहुत ही ब्राइट यंग आईपीएस ऑफिसर है, उसका 8 वर्षों में 27 बार ट्रांसफर हो गया है. 8 वर्षों में अगर किसी व्यक्ति का 27 बार ट्रांसफर होगा तो वो कैसे आम कानून का व्यवहार कर सकता है, न कि आतंकवाद को झेल सके. बट द मोस्ट इंपॉर्टेंट, मिस्टर चेयरमैन सर, इज द मैडम, इन फैक्ट आई एम सॉरी, is the separation, and this is very important, if I may say so, the separation of investigation from operational work. Just consider if your NSG commandos were also doing investigation, if they were also the prosecuting agency, if they also had to file an FIR and a charge sheet in court. Unfortunately, even our crack units, apart from the NSG of course, is doing both investigation and operational work. For example, a very brave officer, a martyr, a great officer, Mr. Karkare, should have been either in operations or investigation. Investigation requires a different set of techniques, training, at the desk, evaluating evidence. Operations require a different kind, not only of physical training, but of mental training. A lot of the successes of these desperate terrorists is because of a certain mental training imparted to them. Well, our operational policemen have to be given that training, and beyond the age, you cannot be in operations. There is no such distinction. In fact, ideally, I believe that in our system there should be a threefold distinction. There should be an operational distinction, an investigation distinction, and a prosecutorial division. What we've been talking about for so long, a DPP, a Directorate of Public Prosecutions. But if you can't have three, you can certainly have two different IGs for investigation and operations under, let us say, a common DGP. It is not to make it disjointed. There has to be coordination and harmony. But certainly, these functions have to be separated from the outset. And if you have this separation, if you have an operational separation from an investigation separation, I ask myself even today, and we all salute those brave policemen and of course those brave army men. They are the only people, only persons we salute, whether it is in Akshardham or in Parliament, whether it is in Mumbai. Well, even today, those policemen don't have an insurance cover. Why is it not possible that you have an operational division of the police where everybody, an enrollment is insured for 1 crore rupees on death, I'm giving an example only, and let us say 50 lakhs for serious disabling injury. Those are people who fight for you, who lay down their lives, but their families today cannot get an insurance cover of 1 crore, the premium of which for this country would be peanuts. Also, we cannot forget the backbone of the system, the beat constable. We talk about beat constables, we give long lectures, but recently I thought it was put very well when I went to a cricket match and I found here on the one hand we give iconic status to our cricketers. Even the smallest first class level cricketer, not a test cricketer, not an IPL 2020, but any cricketer is given virtual iconic status. But the police who guards him on the fence is given far from iconic, demonic status. Well, that is ultimately the way you look at the policeman on the beat. He's the beat constable, his entitlement, his terms of service. These are all things we know we have from the 60s police commission reports which give you the nitty-gritty. We need to only implement, and in fact we need to implement only partially. Even then there will be a sea change. So this is the first and a very important part of my wish list. There are several issues in that which I will not trouble you. Of course, it goes further because you have to ensure convictions and trials, but that's a different issue. The second, Mr. Chairman, sir, Madam Chairman, ये बहुत आवश्यक है कि हम विकेंद्रीकरण की बात करते हैं. डिसेंट्रलाइजेशन बज़वर्ड है. आतंकवाद के विषय में केंद्रीकरण करना आवश्यक है. आज सबसे बड़ी जो एक समस्या है, प्रैक्टिकल समस्या, वो है कि जिम्मेवारी का विभाजन हो गया है पूरे आतंकवाद के झगड़े में. और आज तक भी एक बहुत सरल चीज नहीं हुई है. वो सरल चीज क्या है कि एक सेंट्रल केंद्रीय स्तर पे एक बहुत बड़ा कंट्रोल रूम हो, एक सुपर कंप्यूटर के साथ. भारत के आज के दिमाग आईटी में, कंप्यूटर्स में विश्व भर में सुविख्यात है. उस सेंट्रल कंट्रोल रूम होना चाहिए और कम से कम हर प्रदेश के राजधानी में एक प्रादेशिक कंट्रोल रूम होना चाहिए. और वो एक सेंट्रल कंट्रोल रूम और प्रादेशिक कंट्रोल रूम एक नेशनल कंप्यूटर ग्रिड में, जिसको आप टेरर ग्रिड कह सकते हैं, कनेक्ट होना चाहिए. अगर पूरे देश में एक पत्ता भी हिलता है, एक कोई चिड़िया भी आवाज करती है आतंकवाद के विषय में, तो वो सब कुछ सूचना उस कंप्यूटर में जानी चाहिए. और मुझे विश्वास है कि हमारे जो आईटी के ब्रेन्स हैं वो उसका इवैल्यूएशन, उसका अवलोकन, उसकी समझ बहुत जल्दी और बहुत टिकाऊ तरीके से कर सकते हैं. और ये काम, इस काम के लिए आपको रोड पे भागना जरूरी नहीं है, जंगलों में भागना जरूरी नहीं है. आतंकवाद हल होता है और हल से ज्यादा प्रिवेंट होता है इस प्रकार की सूचना से, प्रोफाइलिंग से, फिंगरप्रिंट से. और सेंट्रल कंप्यूटर होना आवश्यक है. इसलिए इस पूरी आतंकवाद की लड़ाई को केंद्रीकरण करना जरूरी है, न कि विकेंद्रीकरण. Thirdly, the federal agency we've been talking about. Well, it's interesting. I sit on a bench with my esteemed benchmates. The chairman of that committee is here. I'm a member of that committee, Law, Justice, Personnel Committee. We have given a report, the 24th report on 11th of March 08. Perhaps the federal agency need not take much time. We need not be self-doubting about jurisdictional issues or lack of constitutionality. There is a clear answer to my friend Mr. Maitriyan's point about federal structure being violated. The CBI exists. We need to understand the constitutional scheme. There is a specific entry in list 1, in the union list, which reads Central Intelligence and Investigation. We use that to create a Central Bureau of Investigation alone. And we created separate intelligence agencies. That agency should be one just like the FBI. 90% of what you want in a federal agency can be made under that entry 1. Combine the investigation and the intelligence functions under different divisions, but in one common statute. Today's statute, of course, we'll have to amend the statute, we'll have to expand the statute. We have, as you know, the CBI under the Delhi Special Police Establishment Act. We only need to amend the act. No constitutional amendment is required. There will be no assault on federalism. If you have any doubt beyond entry 8, list 1, which as I have said reads Central Intelligence and Investigation, and there can be no direct nexus closer to terrorism than Central Intelligence and Investigation. But if you have any further doubt, you have in the concurrent list the first 3 entries. The first entry is criminal law, the second entry is criminal procedure, and the third entry is preventive detention. And the entry is not just these words. Criminal law entry 1 has a long list of items. Well, certainly, if you are not applying criminal law in dealing with Atankvad, what are you doing? So I think this is perhaps too much of a self-doubt about lack of jurisdiction in any case. If this House decides, or rather this Parliament decides to do so, I doubt very much if any public opinion in this country, or indeed any judicial opinion in this country, will ever think of striking down in the war on terror a enhanced, comprehensive, fully equipped CBI modeled on the lines of the FBI. The CBI will not be the same CBI you and I know. It will be only in name. It will be an enhanced central anti-terror federal agency, and I see no problem. Of course, you need to amend the Act comprehensively to give the CBI all those powers required or indeed today available in our fragmented intelligence agencies. Madam Chairman, the fourth aspect is the aspect which we should never underestimate, and I say this with utmost deference because the Honorable Foreign Minister has already spoken earlier, and he is the best person to deal with it. We are not privy to some of this information. I say this not on behalf of the government. I say this as a member of this House. One cannot underestimate the vital importance of international opprobrium, of international chastisement. In a nutshell, we have to either shame Pakistan into action or render it an international outcast. We can do it by a global blitzkrieg which takes the evidence to the extent we want to disclose it to each state capital, which talks to each state capital in the world, not a state capital in India but abroad, which draws all the nations together in this war on terror. And that international climate opprobrium, I am certain, will either shame Pakistan into concrete action and not mere will-o'-the-wisp promises, or it will render Pakistan into an international outcast, a pariah, which Pakistan can't afford to be. I think, well, this government has already taken very prompt action in the United Nations, but certainly it is entirely possible, and this is for them to consider, for the Honorable Prime Minister, for the Foreign Minister to consider even further special sessions of the General Assembly, where a multi-party delegation can and should go to carry this Indian crusade against terror, against whichever country, and I am not restricting my remarks only to our neighbor on the west, it can be any other neighbor anywhere else across the board globally. Because only then will the people realize that they are all stakeholders in the global war on terror. Madam, the fifth aspect, I hate to quote myself, but I happened by pure coincidence to have written an article which was published today in a leading newspaper. And in there, the thought I am trying to convey is that we react to the front face of terror, the front end of terror. There is a terror incident, of course, we are mostly reactive. We react to the incident, we deal with it, and we have perhaps not that degree of long-term planning. But after reacting, the reaction is also to the front face of the front end of terror. There is in this terror body a middle end and a back end. The middle end are the organizers, the persons who do the broad organization. The back end are the controllers, those who control the puppets, perhaps the funders. Well, all three have to be looked at. And all three have to be attacked. And unless you in fact attack the back end at the base, you cannot deal with the middle end and the front end. There is, and the Honorable Foreign Minister has made it very clear, that the government of Pakistan has been given a very clear indication of what we have and what we want from them. It is very good if Pakistan acts responsibly. And the Foreign Minister is absolutely right in saying that after all we are a peace-loving country and we shall give them an extra inch, an extra yard than necessary. But ultimately what happens if Pakistan, as it has in the last 5, 7, 10 years, not handed over any of these rogue elements, what it euphemistically calls non-state actors? Well, I believe, and certainly again this is for the Government of India to consider, I am only voicing my own personal opinion, I do believe that ultimately international relations and political relations have to be based on some degree of Machiavelli, of some degree of Chanakya. And there are enough precedents, there are enough practices globally in other countries with much less provocation, where the futility of seeking extradition of such elements is given up. And there are several ways known to international relations and practice to neutralize effectively such elements. And that is something which may not come to a stage, because today we hope and trust that Pakistan will honor its commitments. But certainly no option can or should be excluded except the war option, because the war is not an option. The talk about sending missiles from here and landing on Pakistani territory is not an option. War is not an option. If 200, 300 deaths are terrible in Mumbai, hundreds of more deaths will be worse still. But then, as I said, there is enough in international practices and protocols to deal with this situation without either war or without the indirect war of sending missiles there. There are several other ways and means, and I think we don't need anybody except the Government of India, which is well aware of that. We all say, friends, that in USA there has been no major incident after 9/11. That's an important question to ask, and let me deal with some of the reasons why there is none. But while I deal with that, I'll also deal with an aspect as to what the USA has not done, not only what it has done. USA has had no major incident, but look at their planning. Even as we speak in December 08, without any immediate provocation, without any context or any actual incident, there is a report in the press a few days ago that the USA is deputing 20,000 troops. That's a large number for that country. 20,000 troops in different locations in their country to act as a three-perimeter or a threefold barrier against terror. And they'll be deploying them for instantaneous and emergent reaction for the entire gamut of possible chemical, biological, radiological, nuclear, or high-yield explosive terrorist attack. These people, these troops will work with the state guards and the other perimeters. They are based on the concept of a three rapid reaction forces in three perimeters, the first of which is called an active duty combat, is already stationed of about 5,000 troops. The totality is supposed to be completed by 2011. But the point is, this is the planning without any immediate provocation. You don't have to plan in the face of provocation. You have to implement quietly. But see further, there is a very interesting document. There are many, but the most interesting one is a single national strategy for combating terrorism, published by the USA in 2006. There are two earlier ones on national security, but this is a specific document, a single document on national strategy for combating terrorism. It has an overview, and I'm not going into details for paucity of time. It has the parameters for successes, it has challenges, it has a strategic vision for the war on terror. It has a long-term approach and a short-term approach in specific parts of that document. Part of that document is reflected in the National Strategy for Homeland Security, which was unveiled subsequently on 9th of October last year. And ultimately, the Homeland Security, you can call it the CBI in our country, the FBI, whatever you want to call it, a federal agency. It's been handed over to a four-star general in that country. It's been handed over by passing uniform acts with very interesting names the US Patriot Act, the Intelligence Reform Act, the Protect America Act of 2007. So there is a comprehensive, seamless web of a framework to deal with it, and all by way of advanced planning. Now, the same panaceas as there do not apply to us. But the point is not that. The nitty-gritty is not important. The point is a broad framework is available, and you have to adapt and use that effectively in this country. One of the earlier speakers mentioned that much used word POTA. I think it's very important to carry this debate to transcend the POTA or the non-POTA issues in this debate. This is a debate much larger than merely POTA versus non-POTA. But I do want to say that there can be no dogmatic approach about individual constructive amendments if anybody makes them. You don't have to give it a tag. You don't have to, when you say POTA, all the 10 amendments of POTA which are considered draconian get inbuilt into your psyche. But certainly if somebody there was to suggest this particular amendment is good, it can be examined on its own merits. The government of India has never said that it's dogmatic about not even looking at it. But let me just disabuse you of some of the misconceptions popularly held, as if POTA is a magic wand which we will wave and terrorism will end. Of course, there is the obvious answer which is given earlier, that you had POTA and you had Akshardham and you had Parliament and you had Raghunath Mandir and so on and so forth. But kindly remember these few things which are frequently forgotten. Number one, in 9/11, immediately after 9/11, the United States passed a very important act called Patriot Act, which all of us say should be our POTA. But you know that all the special laws of USA post 9/11 are only creating special laws for aliens and non-US citizens. The normal criminal law of USA was not changed for US citizens. The normal law of arrest, detention was not changed. Draconian part of US law after 9/11 was only regarding aliens, and that's the Patriot Act. Huge additional powers, however, qua domestic citizens of USA were given in respect of 2 or 3 areas. What were they? Intelligence, interception, surveillance. Quite frankly, the real tool and weapon to deal with terrorism is intelligence, interception and surveillance. And that part was enhanced considerably against even US citizens. But the rest of the law was changed only qua aliens. And what did we do here? Here, if you look at the Unlawful Act mentioned by my friend Dr. Shori, the Unlawful Act amended in 2004, 70% of POTA, I repeat 70% of POTA with enhanced efficacy has been transplanted there. It's not as if we don't have a large part of POTA. The part of POTA which we have transplanted are very significant provisions. A, the most comprehensive definition of terrorism is found in that act, Unlawful Act. If not found, that comprehensive definition I have not seen in US law and any other law. It covers every aspect of terrorism by what is a terrorist act. Funding of terrorism, enhanced punishment, lot of provisions. Harboring of terrorists, being a member of a terrorist organization, holding the proceeds of terrorism, threatening witnesses, forfeiture of entire proceeds, movable or removable, in relation to terrorism. Terrorist organizations can be notified or denotified. Support to a terrorist organization, the WICO provision. Raising funds for a terrorist organization. All these are found already. Most of these are the ones which prevent terrorist acts. Now, what is not found, about which so much of halla is made? The principal provisions which are not found, which have been taken away, are in 3 or 4 areas. One was a provision in TADA, which said that a policeman can pick you up and keep you for, madam, I thought I had 1 hour 19 minutes, I was taking only 40 minutes.
There's other speakers.
Yes, I'll take 40 minutes, is what I was told by the chair, but
You've crossed 40 minutes.
Yes, very well. I'll try to be as brief as possible. Okay. The areas of taken away from TADA or from POTA related to a 180 days detention period by which you could simply keep a person under arrest without bringing him on a charge sheet. Now, it was found that 98% cases during the 7-8 year rule of TADA never went to trial, but the provision was that you can pick up somebody, keep him for 180 days, not file a charge sheet. Since trial started only in 2% cases, it was a clear case of a possibility of abuse. So what is so wrong in keeping the normal 90 days. You have 90 days to file a charge sheet. In exceptional cases, the court will always give you extra time. The other provision is section 32, confessions, which was talked about. I would be shocked to find if you had a general rule in India that confessions to a police officer are admissible. The USA doesn't have it. After 9/11, they would turn over in their grave if they were told. Well, a police officer's confession is 99% extracted or can be extracted. If you gave that blanket power, today you have a power that you can record a confession before a magistrate on video. That is fully admissible. You can do it for terrorists. On bail, the provision in Pota was that the judge shall not grant bail unless he is convinced that the person is innocent. How can a judge at the interim stage, when only an FIR or a charge sheet is filed, give a finding that the man is innocent? This is a draconian provision. Well, we can certainly consider a more stringent bail provision, but why should you have a Pota provision for bail? And I ask you in actual fact, ask yourself this question: how many times has a court released a dangerous terrorist on bail under the normal law? You don't want the normal law for bail? Kindly consider, give me a single instance of a serious terrorist being released by any court in India on the normal law. Courts are very careful. Courts don't do it. So these are exaggerated political whipping sticks. These are political sticks to beat us with. They don't necessarily improve the war on terror. Yes, I have, and I'll just take a few minutes more, madam. I have a few suggestions for amendment of the law. I'm not saying you should not amend the law. I would suggest, subject to the government's consideration, that yes, we might consider having fast-track courts for dealing with terrorist offences. You don't have to have special courts, they're part of the normal courts. But today you have in India 1,500 fast-track courts, in fact started by the NDA government, on civil and criminal matters. You can create a fast-track court for terrorist offences because the basic object is to get a primary acquittal or a primary conviction within 3 months. Let us say worst comes to worst 6 months. So a primary result is a deterrent either way, and that can be done by a fast-track court. Number two, I think you can consider a demarcation of rights about Indian citizens versus non-citizens. Now this is a tricky issue because in our constitution in India, our provisions apply to non-citizens as well in Article 21 and 14, which is the right to life, unlike USA, which can discriminate between non-citizens and citizens. That's why you have in USA the Guantanamo Bay issues. But in India, we may have a problem. But we can consider that. We can consider even a more stringent provision of bail. Bail can be enhanced slightly. Not the Pota provision, but a reasonable provision which marries safeguard with human rights and yet does not compromise the war on terror. This would be a constructive collaboration of all sections of this House rather than a political whipping stick to try to beat persons with. And yes, we could consider reinstating, this is my suggestion, a provision in TADA that when necessary, subject to a court order, you can shift the trial to the prison. That was a provision which was dropped subsequently, but in extreme cases, a court can give a rule that you can have a trial in prison. Madam, you've been very kind, you've given me time. I only want to say this, that we have truly many miles to go before we sleep. We have those miles to cover. If we have the will, I have no doubt, and the unity, that we will cover those miles. I do believe that is all a question of attitude. As somebody rightly said, attitude and not aptitude determines altitude, namely how high you soar. India has to be ready to try and fail, so long as India is never accused of having failed to try. And since Sher Shairi is the flavor of the moment, may I, with your permission, madam, end by saying that in the ultimate analysis, India is larger than all of us. India is certainly much, much larger than all the terrorists of the world put together. As Jigar Muradabadi said, हमको मिटा सके ये ज़माने में दम नहीं, हमसे ज़माना खुद है, ज़माने से हम नहीं. Thank you very much.
Thank you.